everybody, live from Houston, Texas. Along with me is my business partner, Emily Newman. This is a new year for us, as October 1st is the fiscal year that starts for the USCIS. So October 1st is the January 1st for USCIS. So practically for all the immigration community who rely on immigration, including us, today is the new year. Emily, what do you have today?
All right, today we wanted to update you on the Fairness for High-Skilled Immigrants Act, where we're at in the Senate right now, what the prospects are, what the process is for moving this bill forward. We also want to discuss about L1A manager petitions. USCIS no longer just takes the company's word for it that a position is a manager or uses the job title that says it's a manager to determine that it's actually a manager. So what kind of additional documentation is expected nowadays? We also want to update you that in just 2 weeks, several versions of the forms are going to be changing. This is based on the public charge rule that takes effect on October 15th. And it will likely impact a lot of people watching, but we don't have the new forms yet.
What do you mean?
And we wanted to talk about H-1B denials, increases in denials that we're seeing, and what steps you can take to overcome that.
Emily, on the Senate bill, as you know, that HR 1044 has been passed through the House of Representatives. Now it went to the upper house and it's called a Senate 386 bill, and it was expected to pass, and that removes the per country quota. Then we had Senator Grassley that came with objections and put some insertions with regarding to protecting the U.S. workers, where they put restrictions on putting 30-day notice for the H-1B to be placed at any, before working, they need to have a 30-day notice period of that. And then we have Senator Rand Paul that said, oh, what about nurses? And then the compromise happened and they did amend those things. And then we have Senator Durbin that's coming in now telling that, hey, we passed a comprehensive legislation bill back 3 years ago in which the per country quota was already removed. The House did not take it. What are we speaking about? Why are we passing this law? I mean, come on, where is the end to it? What should people do? Why can't they just take, if they all agree upon that thing, why can't they just pass it?
Yeah, I mean, where we're at right now is trying to get the unanimous consent process so that we can kind of fast track the bill and get it passed in the Senate so that the House and the Senate can then go into conference to come up with a final bill, because the Senate bill is a little bit different from the House bill after these changes that were made. So do you think we're going, and with the unanimous consent, it has to be unanimous, so one senator can block it. Now we're stuck with a different senator blocking it. Do you think we can get this done through unanimous consent, or
especially Senator Durbin from Illinois is blocking this out right now, and he doesn't want any amendment or anything to be added to the bill. He just wants to block it. The reason why he wants to block it is because he passed a bill 3 years ago which has the same thing, and of course it has 1,000 different things other than per country quota limit, including increasing the number of the green cards from 140,000 to 280,000 green cards for the employment based, taking the per country limit off, and it has a lot of different provisions that are probably very good, definitely not, I'm not saying that, but now that Senate bill was never introduced in the House, and he is now saying, well, you never introduced in the House, so why can't you do it right now? It looks very impractical with this Senator Durbin's thing, because even if that bill is to be passed in the House, it has to be passed again in the Senate because it's been 3 years ago. This Senate won't pass the bill that was passed 3 years ago. That's number one. Number two, even if this bill were to be passed in Senate and the House, I don't think so. President Trump is going to sign what Senator Durbin is wishing to will not be signed by Trump. So at this level, the practical thing is for them to pass the bill as it is in the House version, and maybe a little bit amendments that have been added by Senator Grassley and Senator Rand Paul might pass through the House, and Trump should be able to sign this bill. But what Senator Durbin is telling of the Illinois, I don't think so. That his version will be passed. Even if it's passed, President Trump is not going to sign. So the chances for this to go to unanimous looks to be very bleak. Now, having read that, does all the bills need to be unanimous to pass in the Senate, Emily, or what's the other process that is involved?
Right. So again, this is just the unanimous consent. So to fast track the bill. So if we don't get unanimous consent, then we go through the normal process where now we have to bring the bill to the floor for debate. That's where we get into the filibuster. So same idea. You are going to be debating the bill, and then one senator could potentially just speak for it forever and on and on and on, filibuster it in order to block it. And the only way to overcome that is to get 60 votes in the Senate. So I think that we really need to push to get things done as it is without any changes, because adding all of these other provisions, which would be great, it's going to derail the whole process, I think. I just don't see anything happening.
Yeah. I think so. They do have enough votes, even for the 60 votes, to pass in the Senate. The only problem that I feel is that Senator Mitch McConnell, who is the majority leader, might not want to have this one come in there for the floor. If you recall, Emily, the bill that was passed by the Gang of Eight bill that we call as, which increases the number of green cards to 280,000, and per country quota was practically lifted out in that bill. It was passed to 68 votes in the Senate out of 100, and it went to the House. How the House has enough votes to pass, but they never presented it. The Congressman Banner, Speaker Banner, never presented the bill, and it was never passed. So it became dead. So this is all politics that's going on at this point of time. It may be presented, it may not be presented. And I would say to all the people at this point of time, stay vigilant, contact the congressman. I do see lots of messages to write a petition in the for the White House. I think so. That is not important. Oh yeah, I went to the White House thing and put a petition, signed the 100,000 thing. That's not going to do anything good for you guys. I'm practically wasting your time. My suggestion is to contact the senators. And when you do contact the senators, my advice is, please, there are certain talking points that I want you to take a note of those things. One, this bill is treating everybody equally. It is not treating anybody with special categories. If there is any discrimination, that's still under the bill. It still is discriminating Indians and Chinese to a level, but it's okay. The Indians and Chinese can tolerate that much discrimination that's already getting done in this bill. So when you're talking to the people, tell that the Senate 386 bill is treating everybody equal. It's not treating Indians and Chinese better way. It's not. It's just treating everybody as the same. When you look into some of the blogs and messages that are popping up, the hate messages, the Indians are going to take out, the Chinese are going to take out. Guys, the Senate bill is treating everybody equal. They're not treating one above another. The current law that is there is treating one above another, especially putting the Indians and Chinese right in the bottom of the line. But the bill that is about to be passed treats everybody equally. So when you go there, don't tell that, give me special preference. Just tell them that you just want to be treated like anybody else, no special preference for you. Anything else, Emily?
Yeah, I definitely agree that reaching out to your senators is going to do the most good. I see a lot of activity on Twitter, people tweeting and retweeting and copying in or mentioning different senators and news outlets in their tweets. But I don't think you're going to get a lot of response from that. They really want, tweets are 140 characters. How much can you really say? You need to send a detailed letter to them or meet with them, explain the circumstances, talk about your story, make them understand it from a personal level, what it feels like to be in your situation. I think that will go a lot more than just clicking the retweet button or clicking the sign petition button. Those are a lot easier, but much less effective.
And calling the senator's office won't be enough. If I were you, and I was, we did draft a letter. Immigration Girl, Emily has drafted a letter. You can go to immigrationgirl.com and put out the letter that is given. Please give description, how long you've been in this country, how hard it is for you to get the H-1B extension, how hard it is for you if you get a H-1B denial to leave the kids while they're going to school in between. and how many children you have, how many of them are born in United States, do you have a house, what house did you buy, how much mortgage is there on the house, what kind of job you do. Please write all those details and send a letter to the senators. I am not satisfied with you guys if you just write a petition to the White House. I'm not going to be satisfied with you guys if you just call the senator's office and say yes, no to the bill. No. Please make sure that you write a letter, and we have given a draft to it, and write it very detailed and send it. And don't exclude the other groups. When you want to get something, just ask for yourself. Don't try to say that that person is bad, this person is bad. Don't do that. That's not part of you. You just stick to the bill. That's all you are supposed to do. Emily, on the L1A manager, I mean, how easy it is. I mean, doesn't it has to be that if I'm a manager of a particular department, I will get an L1A manager, or what are the qualifications required for an L1A manager?
Yeah, I mean, in the past, I think we could rely on saying that this job is a manager and providing some basic information about the job duties in order to get an L1A approved. But nowadays, I mean, just like we're seeing increased scrutiny on every type of visa, the L1A is not immune to that. So it's not enough to just call the position a manager. You have to provide a detailed job description that it describes how exactly you're managing people. What do you have authority over? How do you hire, fire, pay, and make job-related decisions for the people that you supervise? How are you supervising them? And so in that job description, for some reason, USCIS loves to see the percentage of time you spend on each duty. And I know that's difficult to do a lot of times for managers, because from day to day, your duties might vary greatly, just depending on, managers tend to put out fires with whatever's going on within the business. But you really have to sit down and think about, okay, what are the main things I'm doing, the main actual tasks, not necessarily the responsibilities, what you're responsible for, but what are the actual tasks you're doing to carry out that responsibility, and then try to set a specific amount to the percentage of time that you do on that. Because what they're trying to get at with these percentages is they want to see that the majority of your time is spent doing managerial activities, and that other administrative tasks don't take up the majority of your time. So that's one thing, is a very detailed job description with the percentage of time spent on each duty. Then they want to see an organizational chart that shows your department or your division, whatever you're the manager of, shows where you're at within the hierarchy above you, how high up in the company are you to get to the CEO or the owners, and then how many people are below you. They want actual job titles for all of those people on the org chart. And then in addition, and again, this is for your current job outside the US, plus the job that you're going to be moving to into the US. So you need two sets of these things. But to go along with that organizational chart, it's not enough to just show that you supervise a certain number of people. They want to see that those people that you're supervising are managers or professional level employees. So now, in addition to having the org chart, they want summary of job duties for the people that you are supervising. What's the education required for those individuals? If you're saying that you are responsible for reviewing their performance as part of any job-related decisions that have to be made, you may have to submit sample performance appraisals or performance reviews to support that. Whatever you're saying in the petition, it's not enough to just say it anymore. It's got to be supported with documentation. So if you're saying that you are in charge of X, Y, and Z, maybe you'll have to submit emails from you to the people that you're supervising showing how you are in charge of X, Y, and Z, and what steps you took and what directions you're giving to your team. So all of that supporting documents needs to be submitted. It's not enough to just say this job is a manager anymore. It's not enough just to provide a job description. It's become very difficult to get these approved. Plan on getting a request for evidence. Try to get as much documentation together before filing, and just know that it's going to take more time than it ever has before to get the approval.
A lot of people ask this question to me, Emily, that, oh yeah, I'm going to go for 1 year, work either in Canada or in India and come back and get an L1A manager. And I tell them, no, you need to consult with the lawyer, make sure that things are fine before you leave the country. It's not going to be a simple job to get an L1A, especially in the Trump administration. As the denial ratings have gone up very significantly. I would advise you to just don't take it granted that L1A will be granted if you are going to go out of the country and work there for 1 year to escape the backlog system of the EB, employment-based applications. Please make sure that you have an alternative options. Okay, if that doesn't come in, can you come back on H1B? Since you might have already have the I-140 approval, you may want to consider that option too. Emily, you said the forms are changing on October 15th, which is 15 days from now, which is 485, which is I-129 used for Ls, Os, Ps, Qs, Hs, and a lot of other non-immigrant visas, Ps also. You mean to say they are changing on October 15th and you don't even have a form?
Yeah,
Are you smoking weed or something?
Unfortunately, no. That just seems to be the new method of operation for USCIS, is let's just throw things at people and expect them to scramble at the last minute. So if you are planning on filing a petition towards the end of October, you really can't prepare the forms now. I mean, if you do, you're just going to have to re-prepare them on October 15th and get signatures again, because a new version of the form is coming out. It has to be used starting October 15th. The form most likely won't be available until October 15th. So you really have to time things carefully. If you're planning to file something quickly, make sure it gets there before October 15th so you can use the current version of the form. This is the 485, this is the I-129, and the I-539. So it's used for, the I-539 is used for F1, B1, B2 extensions, L2, H4, all the dependent type of visas. And then the I-129 is for all the work type of temporary work visas. The only real change to the form is asking a question about, have you ever used public benefits since you last received your approval? That's all this boils down to. It's all related to the public charge rule that goes into effect on October 15th.
Yet we don't have the form.
Exactly, yeah. So it definitely throws a wrench into planning things if you're trying to file something in the month of October. At the same time, we also have the new LCA system that went into effect today, the flag system. It takes a little bit of getting used to, but so far, so good. The only issue we're having at the moment is once you initialize and create the form, you don't have access to a PDF version of it, so you don't know what you submitted until you get it certified.
So hopefully the USCIS will extend the deadline, or maybe they will come up with forms a little bit earlier for people to work on, because a lot of the non-immigrant visas use the I-129 and I-539 from A, B, C, D, F, except some forms. I mean, everything is using either I-129 and I-539, A, B, C, D, E, F, G, H, I, J, J which is J. Everything uses these forms, and they're not existing. We yet don't know if this administration really are trying to use the public charge, or they're really trying to block the legal immigration, though. I feel that if they are wanting us to file application October 15th with a new thing, and that doesn't exist today, what do they expect? I mean, A, B, C, D, F, G, H, I, J, K, L, M, N, O, P, Q, R, S, T. I don't know about U visa, but all these things require either I-129 or I-539. We don't have it.
Yeah.
So be careful, guys, when somebody is expiring or anything like that, be careful. They will reject it and you will be out of status for these forms. So be careful if you're having any deadline that is popping up on that. Emily, you're saying that data is showing 32% of the H-1Bs are getting rejected. Where do you get this data from? 32%?
Yeah, the USCIS, since the Trump administration wants more transparency, we have the Employer Data Hub where you can actually look into each company and see how many approvals they got in past years, how many denials they've received. And so the data shows that the overall rate of denial for H-1Bs is 32%, but it's very different depending on companies, right?
Right. If it's a consulting company, the denials are more higher. If it's an end client company, let's say, for example, Google is hiring to place an individual at their own company place, the denial ratings are quite lower for those companies. For the companies like consulting companies that are placing individuals at third-party location, that means that they're placing individuals at a different location, they need contracts and certain other things. The percentage is actually higher than 32%. So I want people to be planning everything in advance to file the H-1B application, especially when the I-94 is still valid. If you get a rejection, you may have multiple different options, but if your I-94 expires and your H-1B gets denied, you will have very limited options staying in this country. So plan ahead of filing the H-1B. Is there any quick tricks that you can tell Emily to be not falling into that 32%?
Well, I think probably the top issue that causes denial is specialty occupation, USCIS questioning whether the job truly requires a bachelor's degree, and not just a bachelor's degree, but in a specific field. And so really take a look at the SOC or occupation code that's being selected on the LCA, see what the Occupational Outlook Handbook has to say about what the education is that's required for that job. There are some codes that now receive more scrutiny than they did in the past, like the computer programmer code. Even systems analyst code has a higher level of requests for evidence and denials. So that's one thing, and then just a very detailed job description, again, kind of like the L1A issue. It's not enough to say that this person is developing software and assume that USCIS knows that a software developer requires a bachelor's degree in computer science. You have to prove it. So you have to list out all the job duties, not just what are you responsible for, but the actual tasks step by step that you do day in and day out, and explain what's so complicated about that job. Why do you need a degree for that particular job in the petition filing? That can help at least eliminate some of the specialty occupation type RFEs. On the consulting side, they want to see contracts, they want to see the work orders that go with the contracts, and they want to see letters. All of that to prove that the employer-employee relationship still exists even though you're being placed at this third-party location, you're being supervised properly, and that sufficient work is available. So they're really looking into do those documents prove that there's work available for the next 3 years, even though that may not be what the regulations and the law actually required, but that's what they're denying a lot of these petitions on.
Emily, a lot of questions are coming from the YouTube and also on Facebook, Emily, is that what is this court case about H4 EAD? And is it that they're sounding as if the judge is going to take off the entire EAD off? Is that a rumor, or is what is that?
Yeah, I think that there were some articles put out shortly after the oral arguments happened that last week that kind of, I guess, implied that the judge was siding with the U.S. worker tech organization and planning on just eliminating the whole thing. So let me kind of give you the backstory. This litigation has been going on for years. It has gone all the way past the district court. The district court actually threw out the case because they said that the tech workers that brought the case don't have standing, meaning they haven't been harmed. They haven't proven, or they're not likely to prove that they've been harmed by the H4 EAD. So then that got appealed. Now the appeal gets put on hold because the Trump administration came in and said they were going to do a regulation. So it was on hold while we waited for the regulation. Then they decided to take the hold off because the regulation is taking forever. The Trump administration is still planning on doing this regulation, but they went ahead with oral arguments. So really the whole issue of the oral arguments is all boiling down to the one thing is whether these workers have standing to bring the lawsuit. It doesn't even get to the merits of the case. The merits of the case are, does the Trump administration or did the Obama administration have the legal authority to grant EADs to people without Congress specifically providing for it? That's what this whole
So once the court rules that the association has a standing, then they go into whether or not Obama administration.
Right. So I would assume if the appeals court finally says, yes, we do think you had standing, now they're going to throw it back to the district court and the whole thing practically starts from scratch on the actual merits of the case. All of that while we have a regulation that could come out next spring.
Okay, now I have some questions from Sachin from YouTube is asking a question. Now that EAD is getting revoked in March of 2020, or so he thinks, should he apply for H-4 EAD? What are the possibilities of these regulations to come out?
Yeah, so it's definitely not being revoked or gotten rid of in the spring of 2020. What's happening in the spring of 2020, that's the earliest we may see a proposed regulation. Potentially, that's the very earliest we might see something. And even if that happens, again, that's a very, what's the word I'm looking for? Aggressive timeline. I think it's going to take longer than that, probably much longer than that. But even if it does, very likely another court battle is going to start all over again about whether the Trump administration has the legal authority
And
to...
we both are going to be part of it.
Yes,
Yes.
absolutely.
We both are going to be part of the litigation where we are going to fight. Emily has created
I did a very detailed report based on a survey that I put on my blog quite a while ago that had over 10,000 responses to it. So I put a study together based on that. So we have the kind of the groundwork laid for one, commenting on the proposed regulation when it finally comes out to explain why we need to keep the H-4 EAD, and then also bringing the lawsuit when they do actually issue a final regulation.
And then we are going to go after the USCIS if they take the H-4 EAD off, and if necessary, we're going to come for you for funding for the crowdfunding for the H-4 EAD litigation. And if you look into the statistics of how the USCIS is standing on the regulations and the executive orders that they're passing, they're losing in court big time. In fact, they just lost yesterday won the expedited removal proceedings with which Trump administration wanted to remove the people without going to judge. That got thrown out of the court. With Emily's blog and with the survey that we have conducted, we are pretty sure that we have good standing to go. Of course, standing, you have the standing, your H-4 EAD is going to be taken off. You have a good standing, we're going to use you to file the litigation. Is that right, Emily?
Mm-hmm. Yep. Okay, question from YouTube regarding someone that has an H-1B visa stamp in the passport but is actually applying for an L visa at the consulate, and the visa officer put that the H-1 visa has been canceled without prejudice. So they want to know, this is Sam from YouTube, wants to know if the person can actually get an H-1B again in the future. So just because they put that canceled without prejudice on the visa stamp, that doesn't impact your eligibility to get an H-1B petition in the future. So as long as you've been counted in the cap before and either have not exhausted your 6-year limit or you have an approved I-140 to get you beyond the 6-year limit, you can still file a change of status from L1 to H1 in the future, even with that notation in the visa. That's just in the visa stamp in your passport so that you don't use that visa when you're traveling, but it has no impact on your eligibility to apply for an H-1B in the future.
Sam asked this question he has applied for the visa status. They said that he's going to get the passport stamping in 1 week. After 3 weeks now on the online status, it says that it's in the administrative processing. Yeah, that happens just because they said that they are going to approve. There is no assurance that it's been approved. So it is in the administrative processing. So it will go through. Typically, it may take any time between 3 weeks to about 3 months to get the administrative processing to be completed. Not much can be done at this point of time if you go for stamping.
Let's see here. Akshay from Facebook. Switching from F1 to H-1B, it's going to take effect, I'm guessing this is a future question, starting October of next year. And his wife is in the U.S. on F2 and wants to know what happens to her status when his status changes to H1. So this is really important for anyone who's changing status in the U.S. to H-1B and has a spouse or kids here that are currently a dependent. Their status does not change just because yours does. You have to file a separate application for your spouse. If you don't file the I-539 to change your spouse or dependent's status to H-4, they go out of status when your H-1B takes effect. So you have to keep that in mind unless they're going to travel. Keep that in mind. Make sure you are aware that you have to file a separate application for your spouse. Every year we get contacted in December with people who say, oh, I just realized I never filed anything for my spouse. I've been in H-1B status since October. What's my wife's status? Unfortunately, they've been out of status since the H-1B took effect in October. So you need to make sure that you are aware of that and don't fall into that situation.
Question comes from Arvind Emily. I think so you need attention. EB1 India is backlogged very much starting from this new year, October 1st. What's your projections?
Yeah, unfortunately, it's not going to become current anytime soon, and it could be years before we get through the current backlog. The latest update we received from the chief of the visa office at the Department of State was that there are 16,000 Indians in the EB1 backlog who've already filed the 485, already been interviewed, and are just waiting for a green card to become available.
16,000. So 70% of the 40,000 is that 2,800 are assured for Indians for sure, but the rest of the people will depend on how much the other countries are using. If the other countries are also using, I know that China is definitely using the 2,800. If the other countries are using, they are limiting the 40,000 though. The Indians will get only 2,800 per year. So that might take maybe 4 or 5 years for it to get cleared. So Arvind, the current situation, as you pointed out, looks very unrealistic. I would say, Arvind, digest it. It is the realistic picture. You are unrealistic at this point of time. Unfortunately, I have to say that because the stats say that the priority date is perfectly there. It's just that your expectations from the EB1 based on the previous history is unrealistic.
Barani from Facebook, him and his wife have current visa stamping with his current employer valid until June of next year, and his wife is in India. He's planning on filing a transfer and wants to know if she can safely travel to the U.S. on H-4 while that transfer is in process. So because your current visa, your current petition is valid till June 2020, and she has the visa stamp already, she should be able to travel. The H-4 is not tied to a specific employer. It's tied to you maintaining your status. Just be aware that when she's entering, her I-94 that she's granted is probably only going to have the end date of your current H-1B approval because you haven't received the approval yet with the new employer. So she'll have to file an extension earlier than normal.
Ramakrishna has this question from YouTube that can he file the court litigation on the H-4 EAD alone? His H-4 is already approved. He's speaking about the court litigation. Our Radio Newman PC is filing every 2 weeks. We file about 50 to 70 cases where the EAD is taking longer than 1 month period. Yes, you can file for the H-4 EAD litigation. Not just Radio Newman PC, maybe the other law firms are also doing, but Radio Newman PC does file about 50 to 70 H-4 EAD litigations every other week. If somebody wants to join, their EAD must have been pending for more than 1 month. If they have H-4 plus EAD, they can join. If they just have EAD pending, only H-4 EAD pending, they can join the litigation. Our next litigation is October 11th.
Kanda Reddy from YouTube has a visa stamp that's valid till February 2021 with employer A, has already changed to company B, and has a new petition that's valid till May 2022. He wants to know if he's going to travel to his home country in the next 6 months. Does he need a new visa stamp with employer B? No, you don't. The H-1B visa stamp, even though it has your old employer's name on it, you can still use it up until when it expires to enter with your new employer's H-1B approval notice. Just be aware, check your passport before you leave the airport to make sure that they give you the new end date that's on your transfer approval notice, not the old end date that's on your visa stamp and your old employer's approval notice. They're supposed to give you the new extended date. If they don't and you leave the airport, you're going to have to go to deferred inspection in order to get that corrected. And a lot of people don't realize it until after it already expires. Then you've got an unlawful presence situation. So definitely check it right away before you leave the airport.
Rajendran has this question. He's in the 240-day extension. His H-1B has been filed for an extension. Can he now file for a transfer of the H-1B application? You can file the transfer of the H-1B application. However, if the previous extension is not approved, you're not going to get the transfer with the I-94. You could do one thing. You can file a counsel processing H-1B with a transfer where you may have to go outside the country to get the stamping and come back. Or you can file the transfer, but you have to wait for this H-1B extension to be approved before you get an I-94 with a transfer application, Rajendran.
Feni Krishna from Facebook has a question about an H-1B extension that was denied. The employer has refiled the extension while the I-94 is still valid and wants to know if you can continue working. So yes, in the event that, this is exactly why we tell people to file your extensions early. So in the event that the extension gets denied, but your previous approval has not yet expired, the employer can turn right around and refile that extension and you can continue working because you still have the valid I-94.
Sridharan has this question. His name got messed up in the labor certification, in his passport, his I-797, and SSN. I have had this problem, Sridhar. In fact, actually, my name is not Rahul. That's my family name. My name happens to be Venkat. And when I wrote my name as what's your first name back in India, we write our family name as first. So everything got messed up. I'm still living with it. But if you don't want to do the same thing, what I did, one easy thing that I would recommend is that go and get the name change in the court. It's so easy to get it done. And then go after all these things and change one by one. Passport, I-797, Social Security, and everything, you can do that. Based on what you're telling is that there are like 5, 6 different versions of your name that are going on. One in the driving license, one is 797, one is passport, one is labor certification. Just get what name you wanted, and then that name will carry on forward for you. That'll be easiest way to get something. Back in older days, yes, I got my green card faster, that's fine. But nowadays, the green card is, is like a mirage for a lot of people. So yeah, you may want to get the name change officially through the court system and get all these things cleared up.
Romy from YouTube wants to know how long it takes to get the green card interview scheduled when you're filing the adjustment of status. So this is assuming that the priority date remains current the whole time it's pending. Then it really varies depending on the local office where you're going to be interviewed at. And you can actually look up those processing times by going to the USCIS website, select the I-485 form, and then it'll give you a list of all the different local offices that are doing the interviews. Select your city, and then it should tell you what the normal processing time is. So it does vary greatly. I'd say anywhere 6 to 12 months is kind of standard, but it all depends on how busy your local office is and how many officers they have available.
Emily Vikram has this political question. I'm not sure it's a question, but anyway, it's worth discussing this. We are shocked that the Democrats are not supporting Senate 386 and Republicans are supporting. What's your comment on that?
Yeah, that is,
In the employment base, though, Republicans have not been that much hindrance, though. The Democrats always want the comprehensive immigration. They want everything. They want to have undocumented, documented people who are semi-documented in one bill. That's what the Democrats are. The Republicans want piece by piecemeal. Let's agree upon one thing. Let's get things out. Let's agree on another thing. Get that. If we have a disagreement, we'll keep that aside. Let's agree on certain things. This I'm only speaking about immigration, guys. I'm not an expert on Republican, but when it comes to the immigration, Republicans actually want piece by piece legislation in the immigration, and the Democrats want the whole. And now when you see the Senator Durbin's objection is exactly the mirror of what the Democratic Party is on the business immigration. I'm not speaking, they want the comprehensive, means overall immigration. They just don't want piece by piece immigration. That's my opinion. I'm not at least on my practice, I'm not a supporter of Republican or Democrat. That's for as far as immigration, they have two different stands that I've been noticing from past 25 years.
Nikhil from YouTube wants to know, if employers are submitting all of the required documents, why are there so many denials? Why does it keep going up? I think that part of it is what the required documents are. The target's changing from a month-to-month basis. So things that we used to routinely get approved a year ago with certain set of documents, now all of a sudden those documents aren't enough. So we start adding additional documents. 6 months from now, that might not be enough anymore. So it's kind of like they're constantly moving the ball and wanting more and more and more. They're not taking your word for it anymore. They need to see the documentation. It's also related to the lack of deference policy that they put out. So just because you were approved before, now that doesn't mean you're going to get approved next time around. I don't know your thoughts on that.
Emily, I think so there's a little bit more depth to this. The documentation, especially for the employer-employee relationship, they're asking, initially they were asking, as Emily was pointing out, that it was the end client letter they were asking. Well, we get the end client letter. Now they're saying the end client letter doesn't have that the position requires degree. Well, now the end client letter position has a degree. Well, it doesn't have the job description. Now it does have the job description. Now they're going back, well, the work order between your employer and the vendor doesn't have the job description. I mean, that's not the normal practice for the vendor to have the job description between the employer and there. That's not normal. So as Emily pointed out, that the target is keep on moving on. The only solution where you get a rejection because of the employer-employee relationship is, I believe, is to go sue the USCIS. And we're getting good positive results when we are suing USCIS. We are tired. I mean, since the time from February 22nd when this memo came out in 2018 to right now, the target kept on moving and we kept on giving lame excuses, which we thought, to the client, saying, well, because now this work order doesn't have the job description. Now this doesn't have the job description. We're tired of all these things. Now, when you look into the employer-employee relationship, though, the regulations are very clear that the employer must have the authority to hire, fire, and pay the salary. If these three requirements are met, they are considered to be employer. Yet you get so many denials with the employer-employee relationship. Why? Because the regulations also say that if the employer has a right to, if the employer does not have the right to hire, fire, or pay, then there are alternative requirements. That says or otherwise control. USCIS has completely ignored the three basic principles and is going into the alternative requirement. In fact, today Emily published an article, our team published an article in rnlawgroup.com. You go to the news section that if you get a rejection for the employer-employee relationship, we are suing and we're going to go take the cases bulk basis, because if we take one case, it's going to cost a lot of money. We're going to club together. If your H-1B gets denied because of the employer-employee relationship, just like the way we are doing H-4EAD, please come and join our litigation. We're going to sue USCIS starting from next week.
Yeah, if you want more information about that, you can email our team at litigation@rnlawgroup.com. Give some of your basic information of your case, and our team will be able to work with you to find out if litigation is going to be a good option for you. Question from Facebook from Surendra. He's outside the U.S. H-1B was already approved. I'm assuming that was in the cap this year, but his employer's not giving a copy of the approval notice. So what can he do at this point? Unfortunately, in order for you to apply for the visa stamp and come into the U.S., you do need your employer's support. So without that, you won't be able to get the visa stamp, and you also won't be able to transfer to another employer because you're not considered counted in the cap yet until you actually get that visa stamped. So unfortunately, you're kind of at the mercy of your employer at that point in order to get that and move to the U.S.
One question we have from UK, from YouTube, is that the H-1B extension has been denied, I-94 is expired, can I leave in 15 to 20 days? If I were you, if my H-1B extension denied and my I-94 expired, I would leave in 15 to 20 days. I would. But I will not answer your question because I will be promoting you for staying undocumentedly in this country. So I'm not going to answer that question. Let me tell you what the consequences would be. That if a person is undocumentedly present in this country for 180 days, less than 180 days, they can still apply for the visa. There is no bar. And the unlawful stay counts from the time you get the denial. So if it's 20 days, you can still apply for the visa without any negative consequences. Having said that, well, would you wait for 178 days and leave the country? That will be irritating. If you do that, you'll be irritating the consular officer. But typically, if people leave within 15 to 20 days, I haven't seen consular officers getting mad. Hey, people have to pack up. I mean, you can't just leave. The kids are going to school. People have cars. People have houses. People have different things. They need to pack and leave. I'm not going to tell you to leave in 15 to 20 days, but I will tell you that I will leave in 15 to 20 days if my denial comes in I-94 expires.
Mudasir from YouTube, his H-1B was selected this year in the lottery, but he hasn't seen any action on it. No approval yet, no request for evidence, and he wants to know if it can be upgraded to premium now. Yes, it absolutely can. So your employer or the attorney has to submit an I-907 form with a premium fee in order to get that done, but you absolutely can do that right now.
The question that comes is that my husband's I-140 has been approved, and it's been approved for more than 1 year, and my husband changed the job. Can I use that I-140 to apply for the EAD? Yes, it's been approved for more than 180 days, so you can use it even if your husband employer withdraws the I-140 approval. You will be fine in getting the getting the EAD approved.
Abhinav from YouTube, his wife's H-4 and EAD renewals are pending. His H-1B is already approved and they need to travel. He wants to know what will the impact be on the pending H-4 and EAD if they travel while they're pending. So while you have an extension pending, you can travel. Since you already have your H-1B approved while you're outside the U.S., she can get an H-4 visa stamp and come back in to get the H-4 extended that way, and then the H-4 application that's pending and the EAD will continue to process, should not have any issues based on the travel.
Sandeep has this interesting question. If I have a child born in USA, what's the benefit? The first benefit is that the child doesn't need us. The child doesn't need any immigration lawyer. That's one benefit to the kid. He won't need an immigration lawyer. For sure. You show the birth certificate, you get the passport, you're definitely the kid. Now, does it benefit the parents? At this point of time, the law requires the child has to be 21 years old for the child to apply for your green card application. And if they do that, the green card is immediate. I mean, there's no waiting period for it. Yes, based on the priority dates, what's going on, you may have a hope getting a green card better with your kid than that of the business immigration that's going on, because unless the Senate 386 or anything relevant to that is being passed, if you apply for the green card right now, it may take 120 years according to us, and according to the Cato institution, it's 150 years. You have to judge whether we are right or they are right. We think we are right, they think they are right. Between 120 and 150, you stand somewhere in between.
San from YouTube has a good question. So we're always talking about priority dates and when it's current and what you can do, but let's kind of back it up a second. What exactly is a priority date and what does it mean when it's current?
The priority date is, for most of the people, there are some exceptions, is the date on which you file the labor certification application. Mostly this is applicable for EB2 and EB3. The day you file the labor certification application is the day the priority date is established. However, for the priority date to stick with you, the labor has to be approved, the I-140 has to be approved. These are the two main conditions. There are other small conditions that are there. For some of the other people where the labor certification is not needed, for example, for physical therapists, nurses, and also for EB1A, EB1B, EB1Cs, the day you file the I-140 application is the day you get the priority date. That is the priority date that you establish. Now, of course, the underlying application has to be approved. Now, what do you mean by the priority date is current? Every month, the State Department publishes a report. Depending on the line, they estimate that how many people are there. They will publish a report saying that before this date, if you are under this category, your priority date is current. That is called a visa bulletin. Every month they do publish it. So you can watch whether your priority date is current or not on the visa bulletin. And we already told you what a priority date is, and this priority date will depend on which country you are born. So if you were born in a different country than India, your priority date may be current, but if you're born in India, it may be backlogged all the way to 2009. So if your priority date is before the date for the country for which you are born in, that means that your priority date is current. You can proceed to the adjustment of status, also called as 485. Any other things that I missed, Emily?
Nope, I think you got it. Ram from YouTube has an H-1B with an approved I-140 and wants to know what's the safest way to seek employment with a new employer without any immigration issues. Well, I wish I could guarantee what works so that you don't ever have any issues, but I would say that generally, if your I-140 has been approved for 180 days, that allows you to extend your H-1B beyond the 6-year limit. That allows you to get the H-4 EAD renewal for your spouse, and that allows you to keep the priority date. So that's the first tip, is have your I-140 approved for at least 180 days before you make the switch. Second thing would be to file in premium processing so that you can get the approval quickly and wait until it's approved before you join the new company. If you stay with your old company and the transfer gets denied, you're fine. You can stay with the old company, no issues at all. But if you join the new company based on the pending transfer and then it gets denied, that denial puts you out of status. So that would be one other tip there. And then just, learn about the company. Check them out on the Employer Data Hub. Look up the company names. See how many cases they've filed in the past for H-1B. See how many approvals they have, how many denials they've had. That information is really helpful.
I may add one thing that I would, at this point of time, Emily, prefer, if I were an employee on the H-1B, prefer to join the company that is not a consulting company. What do you say?
Yeah, I would absolutely agree with that.
Yeah, we have seen, based on the denials, we would advise people, if you have an option, move out of consulting company. The bigger the bigger consulting company doesn't mean that you are safer. It's actually, the statistics show that the bigger the consulting company is, you have a better chances of denial. So try to join the end client. That's one thing. Another thing, I don't know if you covered it, is that I will wait until the approval before I go and join the company B. So that's another safe. If you have an I-94 that is, let's say for example, valid until March of 2020, you go file a H-1B with another company, wait until the H-1B is approved, and then you go join the company. You have a better, you have lesser risk in there.
All right. Praveen Kumar from Facebook wants to know if we can split OPT for 2 masters. Until not too long ago, I didn't know that was even an option, but apparently it is. When you're requesting your OPT time from your school, you have to request less than what you have available your first time around, then you can get the remainder the second time around.
What if I get 12 months OPT, Emily, but I only use 6 months? Can I now go?
No, then it doesn't work. That's why it's very important that you can only request less than what you are eligible for to be able to get more later on.
Now the question that comes from Mehul is that, can a green card holder file for an unmarried son who is above 21 years old? The answer to the question is yes. It's called F2B. That's a category that you file in. The waiting period is a little bit longer period of time. Yes, you can file, a green card holder can file for a kid who is above 21 but unmarried. That's important.
Kedar from YouTube has an H-1B that's approved with consular processing, and it was sent to the Hyderabad consulate. So on the approval notice, it says the Hyderabad consulate. But due to lack of interview availability, he wants to know if he can book in Chennai instead. Yes, you can do that. That's one great thing about the PIMS system that allows any consulate in the world to have access to your petition details and the approval. So you're not stuck only going to the consulate that's listed on your approval. Back in the old days, in order to change consulates, you had to actually file an I-824 application and wait months for the new consulate to be notified. You don't have to do that anymore. Shouldn't have any problems.
Repeated questions.
George from YouTube wants to know if you can transfer an approved I-140 to a different employer. That's a great question. The only time you can do that is if you've already filed your 485, so you're in the last step of the green card process, and it's been pending for 180 days or more, and your new employer is offering you a job in the same or similar occupational category. That's called portability under AC 21. If you have not filed your 485 yet, or it's not been pending for 180 days, no, the approved I-140 cannot be transferred to the new employer. The new employer has to file a new perm, new I-140, but you may be able to at least retain your priority date and port that from the old I-140 to the new if the I-140 was approved for at least 180 days.
One question that came is that my H-1B is expiring on July 2020. I am moving to company B with a receipt notice. What happens if the company B's H-1B gets denied? Assuming that if the I-94 validity is still there, that means that the denial comes before July of 2020. You can go back to the old company, that's what you can do, but you can also file one more H-1B application with the current company using a rule called 60-day rule that came into effect in January of 2017, that if you lose a job and you're unemployed, you can have an unemployment period of 60 days. Even though you got the H-1B transfer denied from company A to company B, you can still file an H-1B either with company B or company C using that 60 days. Now, for the 60-day rule, the number one thing is that your I-94 should be valid with the previous company. If your I-94 expired, that 60-day rule is not applicable. Now, even if the previous company withdraws the H-1B approval, that is not going to have a negative effect. We have used the 60-day rule so many times, have never failed as of now on the aspect of whether or not you're maintaining legal status.
All right, Krishna from YouTube has a good question. Why do the priority dates move backwards?
We promised Emily to bring YouTube just on the video only on the priority dates. We failed many times. We bought a couple of marbles, not couple of marbles, thousands of marbles actually, and different color marbles to try to do experiment. Why does the priority do make up and down? And believe me, 50% of the immigration lawyers don't even know why. I tried to put the marble thing and would try to explain. I did many trials. I did at least 6 trials. I failed every time. But Emily, we need to come up one time to explain why does it move forward and backward.
Yeah, we'll definitely need a visual on that one because it is very complicated to explain. You know, I think a lot of it is to do with supply and demand. And so every month that visa bulletin comes out, it's really a prediction by the head of the visa unit of how far should I move the dates so that I receive enough 485 applications to use up all the green cards without going over. It's like the price is right, closest without going over, right? So sometimes the date gets moved too far forward and gets too many applications and has to move it back to stop people from continuing to file. That's one of the issues that comes up. And the reason for that is they have no idea how many people are in the pipeline. No clue. They know how many people are waiting in the pipeline for consular processing, but for those filing adjustment of status, they have no clue how many people are in line until they actually file the 485.
There's also one other twist to that, is that the countries that are using more than 7% of it, which you probably already know what the 7% is, that no country can use more than 7% when the entire immigration unit is getting used. So what happens is that, let's say 40,000 is there on EB2. The State Department cannot calculate that how much is the demand for the other countries. So in certain period of times, there might be 20,000 left over in one particular year. They may be given to the overused countries. In certain period, there might not be anything left over. If there is nothing left over, the overused countries might only get a maximum of 2,800 green cards. So it depends on how much the demand is for the other countries. The overused countries also will get that much leftovers. It's like this. There are 100 people who are invited to buffet. If 100 people show up, they will say all Indians and Chinese, since you are more than 7 people, you move out. Then they will wait. So anybody coming to the buffet to eat? Nobody is coming. Okay, Indians, you already 7 people, Indians and 7 Chinese are already here. Okay, Indian, come over here, you go here. So depending on how many people come to the buffet is very tough. So the leftover food will be given to the Indians and Chinese. How much is the leftover food is very hard to estimate. It depends on how much the other country people will eat. And that's very tough to judge for the State Department. And that goes on in EB1, that goes on EB2, that goes on EB3. So the leftover green cards. Now, in EB3 particularly, we don't see that many leftovers. We used to have a lot of leftovers in EB1. No longer EB1 leftovers are there. We used to have leftovers in EB2. The leftovers of the EB1, if no Indian and Chinese are still there to take it for EB1, used to fall under EB2. Now we don't see them falling down, so there are no leftovers, not much leftovers in the EB2. And I am using the proper word, guys. I'm not making the word leftovers. It is leftover green cards. Other than the 2,800, it is the leftover green cards that Indians used to get benefited, and those leftovers are not there right now.
All right, I think we're about out of time today. So if we were not able to get to your question, I wanted to make you aware we do have a daily conference call that's free for you to join. The schedule's on our website at rnlawgroup.com. You can join in and ask your question there. We also publish that as a podcast every day, so you can get that off from your podcast player. What else? Write a letter to your senator about the Fairness for High-Skilled Immigrants Act. You can find a sample on immigrationgirl.com. What did I miss?
If the Senate 386 bill passes through, you may not need the H-4EAD. You are in adjustment of status. EB1 may not be backlogged for the overused countries. EB2 might not be backlogged this long. EB3 might not be backlogged this long. You're avoiding 90% of the problem if you have the Senate 386 bill, guys. So if you have anything that you want to do, if you're spending 10 minutes, you just need to spend 15, 20 minutes. Just go ahead, take the letter from Immigration Girl, and then please write it. Don't give an excuse. Make it a rule. Make it a rule for all your friends that if they want to speak with you, they need to write a letter and show the evidence that they wrote a letter. Thank you guys for coming in.
Thanks for joining. We'll see you next week.